We begin with that new decision by the Supreme Court that affects state election laws nationwide. In a 6-3 decision, the court ruled against Republicans in North Carolina, striking down a congressional districting plan. Voting rights advocates are now praising the decision as a major win. ABC News senior Washington reporter Devin Dwyer joins me now with more, along with ABC News senior national correspondent Terry Moran. Devin, just start with a general breakdown of what this case was really about and what this decision means for what they were trying to do in North Carolina.
Diane, this is one of the biggest election law cases the Supreme Court has taken on in a long time, and it was really about who gets the final say when it comes to rules about when, where, and how we vote. Republicans in North Carolina said that the Constitution gives ultimate authority to state legislators, to lawmakers in those states, to be the final say in those rules. Whatever they say goes, effectively, that no court can override them. Critics say that would have removed some checks and balances in our system. It would have really upended state laws, potentially nationwide, by removing court rulings as a protection for voters. And in this 6-3 decision by Chief Justice John Roberts, the court pretty forcefully knocked that down. It was known as the independent state legislature theory. It was going to had the potential to significantly disrupt the election process headed into 2024. And the Supreme Court today said there's really no place for that. So the court system will still be the final say.
Now, Terry, this decision, this case was started in North Carolina, but this affects the whole country. So what are the larger election implications at play here, especially given we are now in campaign season for 2024?
We sure are, aren't we? It's a return to normalcy, Diane. It's a reaffirmation, as Devin said, of those checks and balances that have been part of our elections since the beginning of the country. This was a very radical theory, the notion that unfettered power rests with the legislatures and the legislatures alone to determine the time, place, and manner of elections. No governor could veto it. No court could review it. Election officials did not have powers in that area. It was a sweeping assertion of power. And what this does is basically bring the election discussion back down to earth as we all know it. The legislatures will pass laws, the courts will rule on them, and we will go and vote under the system as we always have. I think it does check what was a movement among some Republicans around the states to essentially grab for more power in those state legislatures where they have almost gerrymandered themselves into permanent power. This will back that off a little bit, but mostly it's just a return to things as normal.
Terry, what did you make of how the justices came down on this decision and the fact that it was authored by Chief Justice John Roberts?
Yeah, Chief Justice John Roberts, the famous institutionalist, he goes slow. There are conservatives, and then there are conservatives who want to go fast. And clearly, in this case, Chief Justice John Roberts and Justice Brett Kavanaugh, also a conservative, but also an institutionalists, they want to go slower, and I think that's what you saw here today. That division on the court among the conservatives, it's a supermajority, 6 conservative justices, but they don't always go in the same way, especially if Justice Clarence Thomas, Justice Samuel Alito want to go faster. You see people like Chief Justice Roberts and Justice Kavanaugh try to put the brakes a little bit on that, and that's what we saw today.
Devin, there's still 7 cases before the Supreme Court, so what are you watching for?
A lot of big decisions still to come, Diane. The next decision day is Thursday. We're waiting to see whether the Supreme Court will uphold President Biden's student debt forgiveness plan. That is that plan that would absolve up to $400 billion in student loans for up to 46 million Americans. Is that legal? Can it stand? We'll also see the Supreme Court weigh in on an LGBTQ free speech case out of Colorado. This is answering the question, can businesses refuse to serve LGBTQ customers on account of free speech if serving them would force them to say something they don't believe? That could have significant ramifications. And then, of course, we're waiting to see the court weigh in on affirmative action in higher education. Can colleges and universities continue to use race as a factor in admitting students? That's going to be a blockbuster decision, 40 years of precedent on the line, and we expect to get all of those by the end of this week, Diane.
All right, Devin, Terry, thank you both.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.